biggest issues that we see both with our clinic participants and in our regular intakes. A huge proportion rather, of those students that we see attended for-profit schools that often sold them what have turned out to be worthless degrees and certificates with promises of near universal employment, well-paid employment, and many of them have never been able to obtain any employment in their field of study. People often come to us years later after years of frustration, and oftentimes the trigger for coming is that they finally get a low-wage job and their payment is being garnished, or their Social Security, disability, or retirement is being offset to pay the student loans. So it's often years later that we hear these stories about these schools and what happened there. Oftentimes the schools no longer exist. So this is not just an issue of indebtedness, but also broken dreams and really lost time for a lot of students. Since the Corinthian closure, we have been inundated with students who attended one of the 5 schools in our service area. And together with other legal services organizations, we've held numerous additional legal clinics to explain these students their rights, which has been a difficult task at times because so many of them are not clearly defined, which is why we really, really welcome this process to clarify that. The students and former students who've come to us via the Corinthian clinics and our intakes tell remarkably similar stories of very high-pressure sales tactics, promises of near universal job placements, promises of high wages, externships that never materialized, false representations about the transferability of their credits to four-year institutions. And to a person, they describe extremely hard pressure sales tactics. So you call to inquire on Friday, you're in class on Monday, and you signed loan documents over the weekend, taking out thousands of dollars in loans. The tales we hear to our ear many would likely be actionable under our state unfair business practices laws, under the California Consumer Legal Remedies Act, and common law misrepresentation, in some cases fraud also. But we wouldn't have the capacity to do complete claims of those types for every single student we've seen hundreds of students. As you know, and why we're here is that there is no general form of application for borrowers seeking discharge based on school misconduct. But as you also know, there's recently been a streamlined form created for certain healed students based on their program of study and when they enrolled. But the distinction that we've seen between students who are eligible and those who aren't for that streamlined discharge highlights the need for further process because it becomes so arbitrary. You'll have students with almost identical facts, but one student, for example, who may have enrolled in one of the named programs 6 months earlier, but describes the same job placement numbers or the same kind of misrepresentations, can't use the form. Or somebody who doesn't remember 4 years ago exactly what they saw on paper, but they remember what they were told. They remember those oral misrepresentations. They cannot use those forms. So I have students who have identical situations, enrolled from 2008 to 2013 in a program that's listed, graduated, looked for work, was never able to find anything, was promised 90% job rates, was promised salary within a certain range, and is still working the same low-wage retail job that she was when she enrolled. In terms of the procedures we'd like to see, I'll just go over a couple and a few key factors that we think are important for the client population we serve, who are among the most likely to be victimized by for-profit institutions engaged in fraudulent practices. So, I mean, much of what we'd like to see involve this being minimally burdensome on the students. And we'd like to see automatic loan cancellation for cohorts of borrowers who are covered by government findings of wrongdoing. So where states' attorney generals, oversight agencies, or federal agencies have reported findings and evidence that a school's established has violated federal or state law or regulation, there should be a process for group discharge of loans within that cohort. They should not be required to individually apply when the department is aware of widespread and pervasive wrongdoing. And I think that the low numbers of eligible students who apply for closed school discharges support the contention that unnecessary applications where the department has the necessary information serve as barriers for students to obtain relief that they're entitled to. And often, the students who do not submit applications are among the most vulnerable. So there may be limited English speakers, they may be disabled or have other kinds of barriers that are preventing them, maybe homeless, preventing them from completing the necessary documentation. Where application is required, any burdens of proof should be fair to the borrowers. Paper documentation should not be dispositive or required. Sworn declaration should be considered evidence establishing eligibility for relief. Again, often by the time the student realizes the extent of the misrepresentation, a lot of time has passed, and the school may have closed, or in some cases seems to have evaporated completely, and it's no longer possible to gain access to supporting documentation. And finally, as I think I was hearing from previous speakers, applying for a borrower's defense to repayment should not require legal expertise. It should be straightforward and should allow students to attest to the facts that would underlie a claim without requiring them to be able to frame these facts as legal claims. And again, we also would like to clarify that this discharge would be eligible to all borrowers in federal loan programs, Perkins Direct and FFEL loans, and those who consolidated their loans. A more comprehensive discussion of each of these points was provided. We signed on to joint comments that were submitted in response to docket number ED 2015 ICD 0076. So I would urge you to review those in your discussions of this for a more kind of comprehensive discussion of our thoughts on this. Thank you.